Welcome to the third hearing of the Committee's inquiry into rural housing and second dwelling reform. My name is John Ruddick and I'm the chair of the committee. I ask everyone in the room to please turn off their mobile phones and to keep it silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media and or others after completing the evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. So we're joined by our first witness. So welcome and thank you for taking the time to give evidence. Could you please state your name and position title and swear either an oath or an affirmation?
My name is Mr. Tom Looms. I'm the Executive Director of Strategic Planning and Policy at the Department of Planning, Housing and Infrastructure. I'll give an affirmation. I solemnly and sincerely declare and affirm that I will well and truly interpret the evidence that will be given and do all other matters and things that are required of me in this hearing to the best of my ability.
Thank you very much, Mr. Looms, and thank you for your...
Wrong affirmation, I thought it might be. Didn't feel right. Felt very weird.
Affirm again.
That's all good.
I haven't heard that one before.
I know, that one felt a little bit more punitive. No worries. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Looms, and thank you for your detailed submission, and we would now like to invite you to make an opening statement if that's of interest.
I think it's all sort of well articulated in the New South Wales Government submission. I'll just make a very brief comment that what's being put forward by the Select Committee, I think it has great intent. We have done a significant amount of housing reform as a government over the last 2 years. My team has been leading that, the vast bulk of that, and the housing SEP has sort of had no stone unturned, with the exception of secondary dwellings. So very interested to see what comes of the report from the Select Committee, because that will help us to navigate any reforms for secondary dwellings that might be necessary. Thank you.
Thank you. Now, there are across New South Wales, there are a lot of unauthorised second dwellings in existence. It's hard to quantify how many there are. Now, if the suggestions of these committees do move forward, what would be your view about an amnesty for these existing dwellings? Because a lot of people are in a bit of limbo and they're feeling there is sort of insecurity about it. And I'm guessing most of these residents, or almost all of them, are safe and stable. But what would you say about a transitional arrangement for those properties?
I think we would have to work it through based on some of the issues that might face some of those secondary dwellings. We have in the past seen unapproved or unauthorised dwellings sort of come to light, usually in a hazard-based situation, when there's been floods and there's been fires. And that is when they're being accounted for, is when they've been destroyed, when people are displaced. And I think any approach to approval or for recognising those dwellings would need to be done through the lens of what other risks that that dwelling may face, whether it is environmental or it is hazard-based. And so as we go through the policy reform process, we would be looking at what those potential risks could be and how such a process could be rolled out, a transitional arrangement if required.
And can I ask, Mr. Looms, how long have you been employed by the Department of Planning?
I have been at the Department of Planning since August 2023, but I was there previous to that as well, from October 2020 until I think it was March 2022.
Right. Okay, well, the reason I ask is in your submission on page 3, you've said, until 2009, secondary dwellings in New South Wales were primarily regulated by local councils through LEPs and development control plans. Yeah. Secondary dwellings became a recognised development type with the introduction of the SEP, affordable rental housing, in 2009. So are you familiar with what was the cause of that change in 2009 and what impacts it had in relation to the second dwellings?
I'm not familiar with the cause, unfortunately. I wasn't in the department at the time. I'm happy to find out and provide more information on notice. I do think that there is benefit in the housing SEP and the standard instrument providing certain rules around secondary dwellings and all residential development types. I think you've seen more of that recently, particularly with dual occupancy reform, which I think nestles quite well into this, the terms of reference of this inquiry. And, I think there is an intent from government for us to have a stronger hand in how the rules are set, particularly around housing.
And then on the next page, on page 4, you said clause 5.5 of the standard instrument was introduced in 2020 as an optional clause that enables councils to set certain controls for secondary dwellings on land in rural zones. Mm-hmm. By adopting clause 5.5 into their LEPs, councils had the discretion to set both the maximum size of a secondary dwelling and minimum distance between the secondary dwelling and the principal dwelling. Have we noticed, I know that was in the middle of COVID in 2020, but do you think that reform that was introduced in 2020 has had a positive or a negative effect?
Well, I think it's because it's an optional clause, councils have to go through a process to establish what are the best rules for their area. So as they're doing their strategic planning, and this was, around the same time they were doing their local strategic planning statements, which was a really important strategic planning document, which every council now has. They can establish where there is the possibility for additional flexibility in housing rules in different zones and what's permitted under the standard instrument. So I think in one of our appendices you'll see a table of where those rules have been taken up by certain councils. Some councils have far more generous floor space requirements than what's permitted under the SEP. They also have different distances as well. Some of them have taken up the distances, some of them haven't. We've also got councils who, for instance, like on that page as well, you'll see Central Coast and Dubbo, Port Macquarie and Queanbeyan, who have established where it is possible in their local government area for that flexibility to be balanced with potential impacts. So potential impacts on rural zones or in conservation zones. Some of them being very flexible in their primary rural zones, so the RU1, RU2 zones, and some also in their conservation zones, particularly the environmental living.
What are your thoughts about the idea of, like, if there are a significant number of additional homes being built in rural New South Wales? What's your view on what we can do, what the local councils can do about raising rates to fund these additional people and the services required?
So rates are obviously outside the planning system, and they're dealt with through the Minister for Local Government and the Office of Local Government. I'm not too sure. I probably can't answer your question on behalf of either of those two groups, but I'm happy to take it on notice and obviously get some further information from my colleagues in the department who work in the Office of Local Government.
Okay, well, thank you very much. Mr Deputy Chair, do you have any questions?
Thank you, Mr Looms, for your presence here today and for your submission as well. I think it's very interesting to look through particularly the appendixes and the variances that exist between councils that have implemented 5.5. And that goes from sort of, Albury right at the top with a 100 square metre limit, or 120 at Griffith, right down to sort of 10 in Port Stephens, which seems like a very, very constrictive secondary dwelling existing there. Just interested in terms of what work does the department do with councils when they're actually incorporating into their LEP? Is there any checks or balances from the department, or is it purely at the council's discretion as to what they implement?
No, so it's part of an LEP amendment. So you'd have to go through essentially a planning proposal or rezoning process in plain terms. It's not something that can just be done straight away. Because it's an optional clause, it goes into their LEP with whatever specifications they've got. Through the planning proposal process, there are always checks and balances. So there would be a gateway process where that basically sets the terms of what the department will be looking for, as well as the consultation required, not just with the community, but also with the agencies that might be affected. Those agencies will be people like the Department of Primary Industries, as well as the RFS and any other sort of response or emergency services agencies about where they're proposing to put or permit or expand the permissibility of certain types of dwellings in different zones. In terms of the maximum square meterage or the distances, council would be required to provide evidence as to how this is not going to have a significant impact on the primary purpose of those zones. So, depending on whether it's the RU zone or the conservation zone, how they're going to limit that impact and make sure that they are balancing the needs of that zone, also with the intent of providing more housing. Some of that would be things like the maximum distance and what the intent of the secondary dwelling reform is. If it's to provide more key worker housing to enable some of the uses in the RU zone. So people who come up and are seasonal workers, if it's to enable that, obviously there's a different approach to how if you're going to use it for a tourism purpose, which is, somewhat a very different need for a different distance, a maximum distance between those dwellings. Each council will have gone through that process individually. They'll have tested the maximum floor space that they think is appropriate for their areas based on the lot sizes and where they're looking to expand those secondary dwellings.
I guess I'll just put to you some of the challenges we've heard through the inquiry so far, to see if the department has any view. One of the areas of frustration from many landholders has been the requirement to have an attached secondary dwelling on a premises rather than a detached secondary dwelling. Just interested whether the department has a view in terms of attached secondary dwellings versus detached, and what sort of mischief could be made in terms of having a detached secondary dwelling in comparison to an attached one?
I think there is a reticence for detached secondary dwellings in some cases because of that, because it's multi reasons. Some is that there could be an impact on the environment. There could also be an impact on the primary use of that lot. So if it's for agriculture, the further that secondary dwelling might be from the primary dwelling, you might be reaching into some of that productive land. There's also the hazard-based issue that generally the primary dwelling has, it mitigates some of those hazards with, asset protection zones essentially to try and prevent significant damage in the case of a hazard. Also, usually the primary dwelling might be positioned in the lot in a place that could also avoid hazards, for instance, things like flooding. The further that dwelling, secondary dwelling gets away from the primary dwelling, I understand that that's some of the risks that certain councils may feel can be mitigated by only permitting attached. It is one of the key issues that the department is very aware of, though. We are, it's one of the sort of primary opportunities, I think, in the housing SEP to really look at how that could be better explained, better managed. We've done it through the dual occupancy reforms as well, because there was an inconsistency across local government areas in their LEPs. Some councils only permitted attached dual occupancies, not detached, and through our reform we've obviously cleared that up.
And now I guess we've had sort of from two angles in a sense. Some who are primary producers on very large parcels of land that say in order to be able to maintain agriculture on their land, that having a secondary dwelling is imperative to either maintain family farming practice or to have additional workers on site. And then at the other end of the scale, we've also had people who've come to us who live on relatively small rural lots that can't be used for farming, but say this is still a large block of land, and having a secondary dwelling would be beneficial to being able to address housing in the area, or being able to have family, for instance. We heard some stories in the Tweed, being able to accommodate family on the site. Just from the department's perspective, in both those cases, what would be the detriment of having a secondary dwelling on those sites?
I guess less a detriment, but more what the opportunities could present themselves as. We really rely on councils through their strategic planning to identify where that flexibility could go, and because parts of the Murray are not the same as Ballina, right? So, but while the zones might look similar or say the same thing, how they're used, what they look like, their lot sizes, what they're producing on those lots as well, is very different. And so I think there is an opportunity for councils, and with the guidance of the department as well, to be able to really closely look at not just all lots zoned RU1 or RU2, but it's more specifically where in those zoned areas there could be more flexibility for secondary dwellings. There are immense housing stresses in the regions, and I think that is driven by multiple factors, has been around for much longer than COVID, was obviously exacerbated by that, and since then continues. So there is a real opportunity for us to look at secondary dwellings as part of the cure in a bespoke way in certain parts of the state. And I think that with the intent of it being for multi-generational housing, or for it to be a downsizer option while also still staying engaged with the family business on a farm, is absolutely a potential. I think there are always risks in land use tensions, and we see it all the time, not just between agricultural and residential, but in many, many different scenarios. But when there is more of that intensive agriculture, which has some impacts which we have to assess quite clearly, I think intensifying residential around those intensive agricultural practices will create a land use conflict that isn't beneficial necessarily to the agricultural sector, and we have to be mindful of that. Similarly with conservation land as well, we have to really look at what the conservation purpose is for land in a local area, and use that as an opportunity to see what flexibility could be allowed in there without obviously having significant impacts on that local environment. I still think there is a real opportunity though for us to consider more flexibility in a lot of these scenarios, particularly in the RU5 and the RU6 zones, where they're the residential, they're the rural village zone, the transitional zones, where we see more of this this rebalancing of that land use change. So I think there is real opportunity there.
Thank you. I'll hand you over to Mr. Fang.
Well,
I'm sorry.
Thank you very much.
Thank you, Mr. Fang.
Sorry, I just wanted to ask in relation to the discussion you were having with my colleague about rural land use and the like. Where does the department receive its advice in relation to prime agricultural land and what impacts may occur on it should a second dwelling be built? Because my experience is that bureaucrats often have a view, but they don't have a practical implementation consideration. So that's, I guess, I'm just trying to understand where the department gains its information from that perspective.
So this was a whole of government submission, Mr. Fang, and it was informed also by our colleagues at the Department of Primary Industries and Regional Development. We, through the creating of an environmental planning instrument, consult with the Department of Primary Industries. I think it's under section 3.25 something, which I can get back to you on. But if a council is putting forward the opportunity to expand, say, the permissibility of secondary dwellings into to rural zones, it will be one of the agencies that council needs to consult with as it goes through that process before the finalisation of the LEP amendment that permits that. On a case-by-case DA process, so if it is permitted with consent, it will be up to council to then consult further if it chooses to with the respective agencies. I think also councils know their local area very well, and in some cases may choose not to, but there are concurrence and referral requirements set out in multiple places, in multiple SEPs and the reg, and so it is very likely that DPIRD, the Agricultural Commissioner, will have views. The Agricultural Commissioner, as you've seen in our submission, is doing further work on state significant agricultural land, how we obviously balance some of those land use conflicts, which is not just residential, obviously there's many, but we will take her advice in those instances because she leads a team of foremost experts in the agricultural practices of the state.
No, thank you for that. And I guess that sort of leads into some of the evidence we heard last week when we were up in the Tweed. I don't want to characterise the evidence that we heard, but I wasn't exactly impressed with some of the views of, say, the mayor of the Tweed Shire in relation to what she considered would be impacts on prime agricultural land from second dwellings. And I wasn't sure as to what the government position was in relation to allowing councils to make their own determination. You've sort of answered that in the in your response, but where a council is perhaps unwilling to adopt measures around second dwellings, and where the view of the department is that the experts are saying that this will or will not have an impact in a certain area, is it fair to say that the department can or should override local government in relation to their objections where they are not fact-based?
So the department has a regulatory role through the planning proposal process, and I guess runs that check and balance. And there is a role at the gateway stage, which is very early on, to set the terms of reference, let's call it, of how this is going to go. And things that must be considered, consultation that must be done, and in some cases can set very clear rules. I will say that it is possible to set the RU1s, the primary production zone, the rural landscape zones, up to allow for secondary dwellings with the right intent. So we've got councils that already have that, and obviously that's been through a process of consultation, and that has been implemented. So it is possible. I think I would be really keen to see the outcomes of this inquiry and what recommendations come out of it about certain zones. Like I said, I think there are certain rural zones where that land use conflict can be managed, where there might be an ability for the housing sector to play a greater role. setting those clear expectations in certain rural zones, but I think we'll take the evidence that is provided from the committee and obviously come up through our own policy work what that looks like. Other things, it's more than just a permissibility issue as well. It then gets down into the development standards and what is I guess right for certain zones. What we know what is right for the residential zones. We are less clear on the rural zones, and I think that gives us an opportunity to set some of those ground rules if that is what is pursued by the government.
Thank you.
Thank
Ms.
you,
Higginson.
Chair. Thank you so much. Thank you so much, Mr. Looms,
No
for
worries.
your evidence and giving time today. I know you live, breathe and digest planning on a daily basis. I understand what that feels like a little bit. I just want to talk a little bit about, ask you, your understanding is that there are some local government areas and LEPs that chose early on in the discussions around standard LEPs not to integrate conservation zones into their LEPs?
I believe through the conservation zone changes that were fairly recent, there are some that still have the legacy zones, from my understanding. I'll find out what they are for you, and I'm not sure whether they chose or whether there was a complexity that might have led to a deferral. But let me find out and I'll come back to you. But there are definitely still some legacy zones out there. Yeah.
Thank you. I think this committee would be benefited by understanding that there are, or possibly some LGAs across the state that, due to whatever political makeup of their councils, they've made
Sure.
decisions not to have the original E zones as they were when the standard instrument first came, and then the conservation zones as they developed. In terms of land use conflict, particularly in relation to rural land and rural landholders, I know that are you aware of a project that the DPI undertook a number of years ago now that related to the land use conflict matrix that they developed? It was referred to as the Land Use Conflict Risk Assessment Guide. It was the DPI, and I'm not sure whether that guide is still in use. It was developed, I think about probably 10 years ago, or possibly over 10 years ago now.
I've definitely heard of it. I don't think I've seen it in recent years, which I can find out if it's still in effect though.
Thank you.
Yeah.
That would be good. I know that it was worked on quite intensively by the DPI Wallingbar Institute and the
Sure.
makeup of... one of the things that they identified, particularly in the Northern Rivers, Tweed and area, about land use conflict is that, of course, rural landholders and primary producers and agriculturalists, of which I am one, we sometimes create massive land use conflict in the way we operate our enterprises, such as tractors and machinery going for 24 hours a day for up to 7 days a week, 14 days a year, in blocks, whilst harvest is on or production. If there was a secondary dwelling close to a boundary of a property, possibly even a large property, is there a way, would the department, would councils, would an inquiry like this or a committee understand what that actually means in real terms, do you think?
I think it would be case by case, which I think is part of the challenge of the planning system. But I think part of the earlier questioning about why some councils only permit attached is to try and avoid some of those neighbouring land use conflicts. So not just on a lot, but also on the neighbouring lot as well, to move away from having secondary dwellings close to the boundary where the impacts on a neighbouring lot or for a neighbouring lot as well could be avoided.
So is it the fact though, say for example, I'm a macadamia farmer and I have a processing facility on my farm, and that means for 4 months of the year I'm grinding very, very loudly nuts, and I'm going, that's my entire business and livelihood. And it's only a small thing, but if I had a neighbour who wanted to build a secondary dwelling on one of those little lots that never got a dwelling entitlement, but it was only sort of 5 hectares in amongst a few big 40, 60 hectare properties. If somebody was proposing a secondary dwelling on that 5 acre lot, say, would it not be the case that it's possible the only way a council or the department or somebody would know of the heightened potential for land use conflict would be through a development application and notifying the neighbours so that they could write in and say, hey, I'm really worried if a dwelling was there and there was a small baby or there was an elderly person, that person may not be able to sleep for 6 months of the year.
Look, it's they're the types of land use conflicts that I was sort of outlining earlier, where those sort of, and it's not just in agriculture, it also happens in industrial land, where we have to be mindful of what the off-site impacts are, but also what those neighbouring lots they also may come under stress as a result, and that if the primary area, the area that you're talking about, its primary use is rural, is agricultural uses, extensive or intensive, that we are mindful of that. So the first check I would really, what I've been kind of leaning on throughout today is that councils need to do that strategic planning work so that they can identify whether the macadamia farming area really is, and the processing really is, the place where we want to see additional residential development. If so, setting up development standards so that those sorts of impacts can be avoided, so that they are not putting secondary dwellings on the boundary near the processing plant for the macadamias, and then exposing both parties to risk. And yes, then if approved through the LEP, then a development application would be obviously one of the key checks and balances that could lead to land use conflict, neighbour conflict as well. And it happens in a variety of circumstances, not just agriculture, but that would be one of the checks and balances. And that might result in the secondary dwelling being brought further away from the boundary. It might result in further changes to what's proposed under that development application, or it might result in a refusal. And I think that's up to really the council to decide that in this hypothetical, but that is absolutely a risk, and I think that's why we need to get the very, very front end of the system right with the strategic planning about where these should go, and what types of zones they should be permitted in.
And is it the case that when planners are planning and councils' planning staff are being council planning staff and they're working in all of their professionalism, that they are looking not just at the current landowner's desires to have their vision or their view or their rights imposed upon their land at that particular time, that your responsibility and your job is to consider land use conflict for the next owners and the next generation and the people after that, and that is something that sometimes may be misunderstood in the community, particularly if a landholder thinks that they're being unfairly dealt with. Is that something that is real for you as expert planners?
Oh, absolutely. So strategic planning really takes that long-term look. It's not the 1 to 5 years, it's really that 10 to 20. And when we do strategic planning, we look at all of these factors where the economic uses for land are going to continue on into the future, and they might change. They do change quite dynamically in a long period of time. Or where economic uses may be retreating and that other uses can start to move in. We see it. We're seeing it in the post-mining landscape. We're seeing it in different parts of agriculture, and I feel like that's what good strategic planners do, is try and balance out that long-term with the short-term requirements of, say, the housing crisis or whatever it might be at that time. We can do that in a lot of ways, but I would say that in regional and rural New South Wales, one of the big factors that we have to consider, perhaps very differently to how we do it in the metropolitan regions, is about infrastructure provision. Obviously, as the councils, as the local governments are obviously sometimes there, and for the dominant part, they're water, wastewater and roads providers as well, and that is a really big thing because where something has been planned for 20, 40, 60 years to provide those services to an agricultural sector, which has a certain amount of needs, and it may not have significant wastewater needs, council needs to plan for the infrastructure well in advance of significant change, which is why that strategic planning, council-led strategic planning, is very important. So yes.
I've just got two quick questions, I think, to finish on. One is, and in terms of what you've just given in answer to that question, is it the same for our biodiversity and conservation? So, for example, landscapes are changing, threatened species are maybe protected, but the only way they can not be threatened species anymore is that they are able to expand in their habitat needs. And so this is also something that is very relevant to where we're putting new homes and that ability for us to regenerate and increase biodiversity across the landscape.
Sure, yeah, absolutely. And look, I think with the C4 zone, which is the environmental living zone, it's very different in Pittwater and Mossman than it is in Ballina or in Bega. And I think there are some really key biodiversity values in our landscapes in regional New South Wales where the conservation zones have been implemented. And they're not implemented wantonly, I would say, by the department. They are done through a very robust process which goes through with our colleagues in DQ, with National Parks and Wildlife. But I do think there are parts of New South Wales, and we've seen that with some councils, particularly the Central Coast, which is constantly wrestling with its biodiversity values and its need for new housing, where there are strategically located parts of the C4 zone or other parts where you could co-locate those and you can manage them through the development standards themselves. So you can, that's why when I was talking about the attached versus detached, limiting the impact on the biodiversity value of a lot or an area can be managed through development standards in some cases, not in all, but the council will be able to figure that out, and it might not be every single lot that's zones C4 or a C3. It might be only some mapped areas where there is that flexibility, but yes, it's a very similar struggle.
And then my last question is, so from a planning and a strategic planning perspective, would you think that it would be counter to good planning outcomes if there was just a blanket provision? I think this is consistent with your evidence, a blanket provision in a SEP that said any lot over 4 acres can have a secondary dwelling anywhere.
Look, I won't prejudge what the committee finds.
I wasn't asking for that. I was asking for your expertise in terms of what is good planning outcomes for the state.
I think there is a lot of flexibility in the standard instrument clauses and the optional clauses at the moment, but I also understand that they're not taken up consistently by councils where they could. And I think there is an opportunity for us to be a bit more firm in certain zones where this could be, where the risks and the land use conflicts could be managed. We've outlined in our submission that the RU5, RU6 zones may present a better opportunity than others. But I also take up the evidence that I heard from the previous hearings where there are struggles with certain councils to actually get them to even consider using the optional clauses in the standard instrument. And I think there's a role for the government to play a guiding hand with those councils to make sure they are, as they're doing their LEP updates, to consider what could be done to help ameliorate some of the significant housing stresses in their local areas.
Sorry, can I just, it's one...
I do have
I've got
number of
one
questions.
clarifying point, sorry.
If
this
the
is
Chair's
all.
happy to do an extension of time.
It's only one clarifying point.
Okay, let's do it quick. Yep.
Just on
We
that,
can look at an
just
extension on that.
clarifying, I think I heard that, so in relation to my question about a hectare, a land lot and size, your preferred approach or your expertise suggests that the zoning is actually the best place to start and then look at the other factors.
That's right. We could get to
Thank
the
you.
development standards later.
Yeah, thank you.
Mr. Barr.
Sorry, that's okay. All good. It's a nice dovetail to the question, some of the questions I had to ask. In the government submission, it talks about the definition of the SEP housing 2020-2021, about the definition of secondary dwellings. And Part C, which I'll just read out, is located within or is attached to or is separate from the principal dwelling. Now, we heard a lot of evidence in Tweed around some of the frustrations rural land owners have there, because currently the approach from council is that it must be attached.
Yep.
Is that one of the areas of reform that this committee could possibly look at?
Absolutely, and it's something we're considering in other zones that are not being looked at by the committee. So yes, absolutely.
The other two things that came up, in particular in Tweed, but also in the first hearing that we've had, was around having to have it on the same lot, particularly in areas where it may have been more, so rural lands that are quite large, it may be more appropriate and safer to put it on a different lot. And the other provision around it must be a smaller size, given a number of the dwellings that are on these rural lands are quite old, 3-bedroom, 1-bathroom, weatherboard homes. Are they areas that we could also look at? And what safeguards do you envisage would need to be in place if we were to start looking at that?
So I think the secondary dwelling versus a dual occupancy is something that I think the committee should consider through its evidence. So, like the purpose of the secondary dwelling obviously is meant to be a secondary dwelling to that primary dwelling, right? So it really is not meant to, in its intent, be able to be subdivided or I guess, split from that primary dwelling. Whereas the dual occupancy, it has that flexibility and that opportunity. And I think some of the things that are described in the draft SEP that's obviously been put forward really do bring themselves more to the dual occupancy. And I'm more than happy that if the committee wants to make recommendations or consider the role of the dual occupancy as well as the secondary dwelling. We've done a lot of reform in dual occs recently, but only in the resi zones, not outside of those.
So tell me, why is it that people are fixated on trying to get a secondary dwelling when they've got this other avenue that they could possibly be using around a dual occ?
So I think secondary dwellings are probably better known generally.
Okay.
I think that's. They also, in the residential zones, have for some time had the compliant development pathway, and also there's providers out there who are able to basically build your secondary dwelling very quickly. And it's also the intent of the secondary dwelling as well really has been to house older family members or younger family members, and to keep them sort of close to home. The dual occupancy is becoming a much more popular development type, and some councils have actually permitted dual occupancies in their rural zones. And
I think mine's one of them.
Yeah, great. And I think there is a real opportunity for, if councils considering secondary dwellings, they may want to consider dual occupancies as well, to give those people that flexibility to be able to decide, if you want to subdivide and split the lot, that the dual occupancy perhaps is the best way forward, looking more at
So how could the dual occupancy reforms apply to rural zones that you've spoken about?
So what we've done previously is we've mandated dual occupancies in all of the low-rise residential zone, which is the R2 zone, which in every LGA in the state, with the exception of a couple who had some really significant hazard issues. So there could be an opportunity through the housing SEP to consider if the committee is putting forward that perhaps the government considers mandating secondary dwellings in the RU5 or RU6 zones, that there is an opportunity to consider something like dual occupancies as well, because they will roughly have the same infrastructure impact, land take impact, but councils will need to consider what that looks like for them in terms of the future of their local area as well.
And so from a dual occupancy perspective, it sounds like there is a little more flexibility around what the dwelling would look like.
Yes.
It can be the same size.
Bigger.
It can be bigger. It can be detached, for
Yep.
example. So it's interesting because I don't think this is something that the councils at least have sort of provided in some of their evidence to the committee so far. Is there any opportunities in terms of the complying development pathway as well for secondary dwellings?
The complying development pathway is currently only enabled in certain residential zones. I think if we went down this policy route, we could look at how it could be expanded further, and we would do that alongside the permissibility and what some of the development standards and risks would be.
Yeah.
I don't want to sort of prejudge what the government might decide on that, but I think if there are certain zones where the impacts can be managed through a CDC, I think that is an opportunity, absolutely.
And a final question from me, Chair. I've managed to get through mine quite
Sure.
quickly. In terms of any unintended or otherwise implications, has the department done any work to consider what might be the short and long-term tax implications by, putting a secondary dwelling on, in particular, primary producer land?
I'm not aware of any work that's been done.
Are you able to perhaps take on notice whether or not that might be something that the
Absolutely.
department could consider looking at? Thank you. That'd be great. Thanks. That's me.
Thank you. Well, thank you very much, Mr. Loon,
Thank
for your hearing today.
Thanks for having me.
Now, welcome, and thank you for making the time to give evidence. Could each witness, starting from my left, please state their name and position, title, and swear either an oath or an affirmation.
My name's Alistair Knox. I'm the chair of the Law Society's Environmental Planning and Development Committee, and I'd like to take the affirmation. Thank you. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you.
And I'm Rosalind McCulloch, and I'm the Vice Chair of the same committee as Alistair.
Yes.
And I take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. Now, would either or both of you like to make a joint opening statement?
I do have an opening statement.
Please do.
Thank you, Mr. Chair. Thank you for inviting the Law Society to give evidence at today's hearing. My name is Alistair Knox, and I'm here in my capacity as Chair of the Law Society's Environmental Planning and Development Committee. I'm joined by Rosalind McCulloch, Deputy Chair of the committee. Our committee members who contributed to the Law Society's submission to the inquiry comprise a cross-section of specialist planning lawyers, some of whom act for councils or are in-house council lawyers, while other members act for developers and landowners. In our own practices, Ms McCulloch predominantly acts for local councils, and I predominantly act for landowners and developers. I refer the Select Committee to the Law Society's submission dated 20 October 2025. In that submission, we support, in principle, reforms to facilitate the construction of second dwellings in rural zones. Our submission did not seek to comment on all of the terms of reference in the inquiry, and I highlight the following from our submission. Firstly, the location in the planning regime. In our view, the proposed changes should be made by amending the housing SEP, the code SEP, and the standard instrument LEP. Clause 5.5 of the Standard Instrument LEP should be amended or removed to avoid inconsistency and confusion. An approach where the local environmental plan retains a clause which is always overridden by the state instrument should be avoided. Impacted zones. The terms of reference at 1 subclause C refers to permitting second dwellings on RU1 through to RU6, C3 and C4 zoned lands. We suggest that the new policy, if implemented, should only extend to RU1, RU2, RU4, RU5, RU6. Given the objectives of Zone C3 environmental management and C4 environmental living, we do not regard it as appropriate to extend the new policy to land zoned environmental management and C4 environmental living because of the objectives of those zones. The objectives of C3 environmental management under the Standard Instrument LEP are to protect, manage and restore areas with special ecological, scientific, cultural or aesthetic values, to provide for a limited range of development that does not have an adverse effect on those values. The objectives of Zone C4 environmental living under the Standard Instrument LEP are to provide for low impact residential development in areas with special ecological, scientific or aesthetic values, to ensure that residential development does not have an adverse effect on those values. On that basis, we take a narrower view of the appropriate application of the proposed reforms. Our submission also raised a number of technical points and matters for further consideration. Firstly, with respect to strata-like agreements and arrangements, the terms of reference and the draft instrument refer to strata-like agreements and arrangements. It is not clear what is intended by these references, and we suggest that this should be further considered. In principle, we do not see any reason why strata subdivision should not be permitted as a means of providing two dwellings on rural land. Secondly, the definitions of second and principal dwelling. Page 2 of the draft instrument provides a definition of second dwelling. However, there is an existing definition of secondary dwelling in the dictionary to the Standard Instrument LEP. We suggest that adding a new definition for second dwelling should be avoided. The draft instrument also includes a definition for principal dwelling on page 2. We query whether it is necessary to allocate one dwelling as the principal dwelling in the context of permitting two dwellings per lot in rural zones. Thirdly, consideration of rural workers' dwellings. Arguably, the Standard Instrument LEP permits more than one rural workers' dwelling to be built on land in certain zones. Some LEPs, such as Ballina Local Environmental Plan 2012, Section 4.1, capital C, include a limit on the number of rural workers' dwellings allowed on land within certain zones. We query whether it is intended to permit rural workers' dwellings in conjunction with a rural dual occupancy. If so, the two dwelling maximum limit should be amended. General clarification should be given as to whether more than one rural workers' dwelling is permitted. If more than one is permitted, but only in conjunction with a single principal dwelling, then that should be made explicit. If not, there may be no utility in maintaining the rural workers' dwelling as a separate category. I think it was the fourth point, is rural land sharing communities. Given the nature of the inquiry, we suggest that State Environmental Planning Policy Primary Production 2021, Schedule 5, Rural Land Sharing Communities, is also relevant. Schedule 5 is the main provision that allows community or multiple occupancy living in some rural areas carried over from earlier state environmental planning policies. In our view, any interaction of the new policy with provisions in respect of the rural land sharing communities should be considered. We also note there are limited zones where new rural land sharing communities can be approved. Access arrangements. As highlighted by the terms of reference at paragraph 1J, consideration will need to be given to access arrangements. Some LEPs require a single access point for two dwellings. For example, clause 4.2 capital D, subclause 2, subclause B of Byron Local Environmental Plan 2014. Setbacks. we suggest that 3 metre side and rear minimum setbacks as provided on page 5 of the draft instrument appear to be unnecessarily small for a large lot, and consideration could be given to a sliding scale based on lot size or lot width. Thank you again for the opportunity to appear before the committee today.
Thank you, Mr. Knox. Now, you have said in the opening in your submission that the Law Society does in principle support the concept of liberalising the second dwellings and rural properties. And now, if this committee or this inquiry in this parliament comes to that same view, then the question is, how do we actually tackle the planning regime to bring about these reforms? And you have said that in your view, we should change the housing SEP, the code SEP, and the standard instrument LEP. Could you elaborate on that point, please?
Certainly. So it's suggested in the I don't know what the term of the document that you've prepared is, the draft model instrument, that the preference would be to include it as a new chapter to the housing SEP, and in principle, as a matter of consolidating clauses relating to rural dual occupancies into one place, that's sensible. There's also a suggestion that there may be provisions relating to complying development, which would go into the exempt and complying development SEP. Again, if that is a policy decision which is made, then that would be something which would logically go into the code SEP. And there is an existing clause within the local environmental plan, clause 5.1, which is a standard instrument clause, which relates to rural dual occupancies. The point we make in the submission is that there shouldn't be clauses in the LEP which are always overridden by the state instrument, because that just creates confusion when somebody reads the LEP as the first point of reference without being aware of what's happening in the state policy, the housing SEP.
Thank you. Now, I'm fairly confident there's going to be lots of questions for the Law Society, so we might start going counterclockwise this way, so you don't miss out on time.
Thank you. Thanks, Chair. I only have one or two. I wanted to start by thanking you for your very detailed and quite technical submission. I did appreciate it. I wanted to ask you, in the submission you mentioned about setbacks, which you've said could be unnecessarily small for a large lot, so suggest we consider a sliding scale. What could that look like in a draft model instrument? Have you got any suggestions?
Yeah, sure. Well, the idea of a sliding scale is to make the setback proportionate to, say, the width of the lot.
Yep.
So you could say that it would be a certain proportion of the width of the lot on either side. If it was to do with the area of the lot, there might be a more complicated calculation to figure out the sliding scale. But often in a rural context, 3 metres is very close. So that's why we're suggesting that it might be better to look at be able to have an instrument provision that's sufficiently flexible to take account of smaller lots and larger lots.
And I think where you often see that in existing LEPs is a sliding scale for floor space ratio for dwelling houses. Yep. In many LEPs, you'll see that rather than a flat 0.5 to 1, for example.
And you've also mentioned, in terms of the impacted zones, that you don't regard it as appropriate to extend the policy to C3 and C4. Could you expand on that a bit more in terms of the objectives?
Okay. Well, just because of the objectives of those zones, particularly if you're allowing complying development, which doesn't have to have regard to any of those objectives, they could effectively be ignored for the purpose of a complying development. So those are particularly sensitive areas that need to be considered on a case-by-case basis.
We heard from the earlier witness this morning, I'm not sure if you were here to hear the evidence, that the RU5 and 6 may present better opportunities than others for some of this secondary dwelling reform that we're looking at. I just wondered if the Law Society had anything to proffer on that.
Not from the Law Society's submission, and from my own personal experience, I'm not so familiar with specific rural LEPs, so I just don't know the prevalence of those RU5 and RU6 zone lands.
The other thing that I was interested in, and the chair's obviously touched on this as well, but having an LEP with a clause that can always be overridden by the state instrument, are there any other suggestions that you have for the committee in terms of what we could look at? You've mentioned clause 5.5 in particular. How should those instruments be amended so that we're not going to come up, and if we're sort of looking at new policies or new reforms, what steps would you suggest the committee take to avoid any of those sorts of clashes, if you like?
Thank you. That's a good question. On top of the clause, and I think I might have incorrectly said 5.1 before, it's clause 5.5.
Yep.
There's a note in here about the interaction of the definitions of second dwelling, which may arise, secondary dwellings, rural workers' dwellings, dual occupancies, which doing work even in metropolitan areas, the nuanced differences between those different definitions when it comes to having one or two or three dwellings on one lot of land often becomes quite difficult. So a particular consideration of how those definitions are intended to operate together, and even potentially considering them becoming mutually exclusive sorts of definitions. So if you are a rural dual occupancy, you're not a secondary dwelling or a rural workers dwelling, should be considered. A matter which I've come across personally is where you have more than two dwellings. For example, if you had a principal dwelling and two rural workers dwellings, you have three dwellings on one lot of land, and then you fall into the territory of multi-dwelling housing. So there also needs to be consideration of how the definition of multi-dwelling housing operates with those other definitions.
And just a final question from me, Ms McCulloch, I think in the opening statement you mentioned you had some expertise in working with local government.
Yes.
In this space. I just wanted at a very top level, if you could relay to the committee some of the challenges based on your experience in that field of work.
Yeah, I wouldn't say I have a lot of experience in that area, but one of the things that councils are very concerned about is not allowing fragmentation of agricultural land, and to ensure that any new dwellings, at the moment the regime is a little different, but to ensure that they're related to the agricultural use of the land and are not going to just become an Airbnb for somebody to use, that they're actually providing housing for people in the regions.
Thank you. Thanks, Jeff.
Thank you, Ms. Saval. Ms. Higginson, do you have any questions?
I do, but I'm happy to come after that. Thank you. Thank you both for being here. I know that I have had dealings with Ms McCulloch in a previous life on the Environmental Planning Law Association committees. I'm just curious about, and particularly you, Ms Culloch, also in relation to working with councils and that view of councils. Is it fair to say that councils, in terms of planning their instruments, their LEPs, that they work incredibly hard with their local community to make sure that their instruments do reflect in the best way possible the local character of their communities?
Yeah, I'd say that's correct. Most of them take years in planning, and then they get nuanced and tweaked along the way over time.
And particularly there's quite a degree of consultation that goes into the making of those instruments.
Oh,
so
yes, a lot more than would go into the making of a SEP.
And it with... I know that some of the evidence, and this may be material evidence that questions that you could answer to Mr. Knox. You've presented on that potential inconsistency in definitions with dual occupancies, secondary dwellings, second dwellings, and so forth. Is your evidence that really these things and matters need clearer definition and better reconciliation in terms of the impacts that they will generate across the landscape and lot by lot basis?
So from my perspective, it's more of a legal consideration, the reconciling those definitions than the impacts which arise. But that is to say, sometimes confusion about definitions and entitlements on permissibility do give rise to unforeseen and unintended development applications, resulting in more dwellings than can be accommodated on the land, for example. So although I'm strictly going to the legal point, confusion on the legal point can result in unintended environmental impacts, certainly.
The evidence about conservation zones not being applicable, the most appropriate zoning to just have a, for want of a better term, an overriding principle that allows complying development that says, you can just have a second dwelling. Do you have any awareness in terms of the uptake of conservation zones across New South Wales by each council in your interactions? For example, my understanding is that there are some councils that chose not to apply conservation zones to their LEPs. Do you have any awareness of any particular councils that you may have worked with or proponents within LGA areas where there aren't conservation zones?
So I will let Ms McCulloch answer this specifically from the perspectives of the councils that she represents. From my perspective, the majority of my work is naturally in metropolitan council areas. I do have occasional matters in the regional areas, but for the metropolitan council areas, you rarely see the RU zoning, but you do often see the conservation zoning. That's the only observation I would make. You do see C3 and C4 zoned land. You don't see rural zoned land very often.
Do you have any?
I wasn't actually aware that there'd been some LEPs with no conservation zones. I guess it may depend on the quality of the landscapes in those areas, but certainly the councils that I've dealt with have all had conservation zones in their local government, in their LEPs.
I just recall there was a real kind of politicisation when the standard instrument came in with the E-zones, and there was, I know all the councils in the north didn't impose or introduce any, and they had all these deferred areas. Do you deal with many deferred areas anymore in terms of zonings?
There's still a few pockets.
Yeah.
Interestingly, I know in Northern Beaches had a pocket in Oxford Falls area. I don't know if that's been resolved yet, but it makes for bad planning.
Yeah.
Because you have multiple instruments applying in the same local government area, and it's hard to get them to work together.
So perhaps
part of that Northern Beaches problem, the amalgamation, because I know looking at a couple of different zones in the Northern Beaches, there's also challenges of what was the old Pittwater LEP, the Manly one.
That's just an added layer of challenge.
Okay, fair enough. Good for clarification.
bonus.
The deferred is really a hangover from where it just got too hard, I think, to decide what to do with an area. There was a lot of pressure to get the standard instrument LEPs through, and so rather than make a decision or whatever the problem was, I think with Oxford Falls it was topography, bushfire, ecological issues. There was access. There's a lot of issues down there, so it was a very difficult area to plan for. But leaving it for so long as a deferred matter wasn't very helpful.
But it's fair to say then that for this committee's purpose and this inquiry, it would be important to be cognisant of the fact that there may be these deferred zonings that could have relevance in terms of how our recommendations in relation to any changes to how secondary dwellings might apply across New South Wales.
It could, yeah. I don't think it's contemplated in the draft document, but yeah, it could.
And then finally, just in relation to, and perhaps this is you, Mr. Knox, or you, Ms. McCulloch too, but in terms of those more metropolitan conservation zones, I know your recommendation is that we probably shouldn't be having secondary dwellings in those places without some form of assessment process being taken place. Do you see that these things could, or need to, take into effect other requirements for housing, such as asset protection zones, and that likewise with rural zones could have significant impacts on the environment, and again that's one of those unintended consequences possibly?
I certainly think it is, and I suppose if this is the difference between it being permitted as a development application and as complying development, then that is crucial. Asset protection zones, obviously very important. Conservation, biodiversity conservation layers, quite important. Existing services, sewer and stormwater, very important.
And flooding.
And flooding.
And flooding, yeah. And oh yeah, go on.
Mr Deputy Chair, do you have questions?
Yep. Thank you very much. Thank you, Mr Knox and Ms McCulloch, for your attendance here today and for your very extensive submission as well. I think it's very much appreciated and speaks for itself in large part due to the technical issues that you've raised in it. But I just wanted to ask, with the time remaining, a couple of questions in terms of the motivation of the committee to come down on the side of supporting changes in this area. Is this a problem that members of your committee have encountered regularly as they're trying to get a secondary, or trying to work with the settings for secondary dwellings across New South Wales?
I can speak for myself personally on this point because I did contribute to this submission on behalf of the Law Society personally, and the point with respect to rural workers' dwellings, secondary dwellings, multi-dwelling housing, is a point which I have had run through the Land and Environment Court, a matter of interpretation on those different clauses, and so that point was specifically raised by me in my contribution to the submission. Otherwise, I think your question started by saying that the Law Society is generally supportive of the proposition. I suppose that comes from a base understanding from the committee members that there is a housing shortage, a housing crisis, and that steps need to be taken to address that housing crisis. The question of the nuances in the legal detail and where that housing is most appropriately located is more of a policy-related question.
I guess one of the challenges that we've encountered throughout this inquiry are people who have sought to have a secondary dwelling put on rural land. Under the council's laws, that it may be permissible to have a secondary dwelling, but then they have encountered further problems, either being in terms of the size of the site, the requirement to have that secondary dwelling as an attached dwelling rather than a detached dwelling. Are these the kind of issues that some of your clients are facing as well as they're navigating the system?
Well, in answering the previous question, I mentioned some litigation that I'd been involved in. That was litigation on behalf of a landowner developer seeking to, actually in that case it was seeking to regularise some existing dwellings which existed on the land, in fact, prior to them becoming the landowners, and difficulty in regularising the land use of those additional dwellings, where in that case it purely came down to a permissibility question for the additional dwellings. There were no contentions relating to unacceptable impact. So obviously, even on interpretation of these terms and permissibility, it can sometimes be difficult to obtain approval for these things through councils.
Okay, thank you.
Well, thank you very much. Oh, well, does Mr Fang have a question for us today?
No, I'm okay, thank you, Chair.
Okay, thank you. Okay, well, thank you very much for joining us.
Thank you.
Thank you.
Joined by two representatives of Lydia's Legacy, which is a Southern Highlands-based charity for homeless people. So can I ask each witness, starting from my left, to please state your name and position title and swear either an oath or affirmation.
Yeah, thank you, Mr. Ruddock. My name is Paul Riley. I am the chair for Lydia's Legacy, and will take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Raymond Courier, and I'm a member of Lydia's Legacy. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Well, thank you, Mr. Riley and Dr. Curry. Do either of you have, or both of you have a opening statement?
I do, thank you.
Thank you.
Thank you and good morning to everyone. Lydia's Legacy is from the Southern Highlands. We are registering as Lydia's Legacy Southern Highlands Homelessness. And thank you. And it started basically as a group of many of the churches in the area looking to how can we specifically help the issue of homelessness. We've realised that there is a lot done by churches in the area for various aspects of homelessness, and we realise now that the actual problem of accommodation, medium to long term, is the biggest issue. We know that there are around 80 people per night that are doing it tough in the Highlands. I asked the head of Vinnie's what she thought that number had sounded too high to me. She said that in the first 3 months of this year there were 300 inquiries as to trying to find a home for people, and obviously an overflow from Sydney. Because of the predominance of larger properties in the Highlands, this is where we've come up with this idea of putting tiny homes onto properties. And it's interesting just listening to the previous people who've spoken, and especially from the Law Society, that the word tiny homes conjures different things in different people's minds. For us, we are talking about a vehicle that is on wheels and can be towed to the site. We are setting up as a charitable organisation, and we realise that government is not the only place where we can go for help in this. We are looking for philanthropists to pay for the model that we have chosen. We are expecting that we will be able to put a tiny home on a property, and for 10 years that tiny home will be used for the purpose of housing homeless people. In that time, the person who owns the property will have minimal impact, minimal cost to them in terms of even purchasing. They won't even have to spend any of their own money on purchasing that tiny home. That's part of our model. We're partnering with Argyle Housing, who is the community housing provider in the area, and currently that is happening even as we speak. One of the things that we are very aware of, and we've had the Mayor from the Shire come and speak to us, and he used the term NIMBY quite often. I'm sure you've all heard the term by now. It's something that we're very, very aware of in the area, and that's why we think larger properties enable us to put tiny homes onto the properties with minimal impact on other people. And we know that that's a big consideration probably for any council. Our biggest issue and the subject of our submission was Clause 77 of Local Government Regulation 2021 and some of the limitations. If those limitations with regard to occupancy of tiny homes were to be altered just for the purpose of homelessness, addressing homelessness, we believe we could solve a massive problem across not just our area, but a model that can be used in many parts of the state. And we're looking to put people in tiny homes for not a specific time, but we envisage it would be months, not years, because we want people to get back on their feet and to move into affordable housing as they go. And the affordable housing model that we are looking at is probably more specific to this committee, in that we would look at some of the larger properties to be able to put a couple of tiny homes on them, and people could move to them and start paying a little bit more for that. But that's a model further down the track.
Thank you. So when we think of the Southern Highlands, we generally think of them as a relatively affluent area. So you're saying that there is an increasing homelessness problem, but this is people leaving Sydney to go to the Southern Highlands. Have I got that correct?
We don't know. One of the biggest aspects that a lot of the people that have gathered data on this have said is there's a lot of people that are sleeping in overcrowded accommodation, so they're couch surfing. Very hard to capture that information, but we know that there are young people sleeping on the trains, which finish at about 4 a.m, but in winter time they're nice and warm. A lot of people are sleeping in their cars. They have a job and are sleeping in cars. There's places like, and anybody here that drives south would know that Sally's Corner Servo is the Shell service station that's probably about an hour and a bit from here. A lot of people are sleeping there in their cars because they can use the bathroom facilities at the service station. But we know also that the largest cohort of people that are now becoming homeless are older women and women escaping domestic violence. And these would be the predominance of people that we would be looking to try and help.
And so you think the solution is these, or a large part of it is these tiny homes, these mobile tiny homes, which are small, but someone can live in it and there's all the facilities that they need. But have we got landowners that are prepared to house these tiny homes?
It's funny, I went on the radio recently asking for people to give us a property that we could just use as an example to give to council. And all of the people that rang were outside of the Wingecarribee Shire. But they were really willing, they're really keen to be able to do it. We believe that there would be a lot of people, because of the model that we want to use, where philanthropists will pay for the tiny home. And the value of that we're looking at is somewhere between 90 to 120,000. 120,000 buys you a pretty nice tiny home. And that's a great example, we think, of something that could be quite adequate for people for quite some time as well, and why it would be a good solution to a longer-term housing crisis.
So the impediment to these tiny homes being a solution to the homeless crisis is this rule that a tiny home cannot be occupied for more than 2 consecutive days.
Yeah.
So it's basically looking at like an Airbnb style accommodation, or not more than 60 days in a 12-month period.
Yep.
So if we remove that, you think that there will be a significant increase in the amount of these tiny homes, and it will solve your homeless problem?
The bigger part of those clauses, I think there's 5 that we've addressed, or several that we've addressed. The 60 days is one aspect. You can have people stay longer in a tiny home if it's a farm property and you've got your farm workers staying there, so it's for a seasonal use. But it says also that somebody has to be part of the household. Now, it doesn't say family, but it says household. We would like, and why we would like to be involved with choosing who goes into a tiny home and the people who would house the tiny home. We want people who are willing to be a bit considerate and do welfare checks for people who are going to stay in these tiny homes, so that they would not just feel like they were just a tenant, but somebody who has been a bit looked after by the people who own the property. We can't do that because the regulation actually prohibits that unless they're part of the household, so it's a definition. And I noticed the previous gentleman saying that some of the issues are about definition, and that's one for us. The other one is, and one that we would like probably a bit of flexibility on, is the last of the issues in clause 77 is that you can stay there indefinitely if you're escaping disaster. Now, it might be a stretch, it might not, but we consider homelessness to be a disaster. On a personal level, it is certainly a disaster for those people. So can that generally be considered for this purpose? We don't necessarily even need anything changed, just an understanding that for the purpose of getting homelessness down, we could actually put people into these tiny homes quite easily, quite simply now, if we could have an interpretation of those sort of regulations that enabled us to.
Mr Deputy Chair, do you have some questions?
Yes, indeed. First of all, Mr Riley and Mr Curry, I want to thank you and your organisation for the work that you do and for the intention that you have in the Southern Highlands, and to pick up on the Chair's point of the perceived affluence of the Southern Highlands. My wife is from Mittagong. She was a former councillor on Wingecarribee Council, and the circumstances you speak of, I think, are ones that very closely confronted her family as her mother and father went through a divorce, and they'd had a suburban house in Mittagong, but then her mum ended up getting a fairly small accommodation in Welby down the road, and I think many of those lots don't exist, but when we first encountered, my perception of her was that she came from Mittagong, she must live on some large acreage or the like, and it isn't the case for everybody in the Southern Highlands, and particularly for the challenges of the haves and the have-nots in the Southern Highlands as well, where you have, of course, large properties and people with wealth and affluence, but then the people who service them who can't necessarily afford to live in the region. So I commend you on your work. Just in terms of your proposition, and I've had some interactions with the manufacturers of these premises as well, whether they be tiny homes or caravan homes or the like. But this is a problem generally across New South Wales, and I guess the argument from many councils is, well, you can have this, it just requires the development application to be made. Now, as you're outlining in your submission, that while that may be the case, you find it's 2 years. Is that the case for that to be able to get through?
We know that it can be a lengthy process. On that issue, I can understand where this problem comes for council, because I started work as a mechanic many years ago. I worked in the automotive industry for a long time, and the automotive industry has specific rules for the construction of vehicles and sale of vehicles in this country. And so they're Australian design rules, and I've actually worked on some of these when I worked for Jaguar. So that is the standard that the automotive industry uses for quality. When it's building, it's a very different animal. And so I understand why council have the reticence that they do with tiny homes, because here's one standard, but here's another, and they don't necessarily know much about the automotive side of it, and whether it's a decent standard when it becomes applicable to housing. So I can kind of get that, but if there was some way of marrying those two together, or for recognition of the fact that you don't need a DA, because a DA is a development application. You don't need a DA for a tiny home where it's been built to a very high quality standard, and that's all we're looking at. We're not looking at overseas manufactured tiny homes that are cheap and nasty, which some are. We're looking at the tiny homes that are very, very good quality, and any inspection of these will actually reveal that they are very, very well produced.
And in terms of the appetite you've got in the region, are there many landowners who are coming forward who are happy to accommodate these premises on site?
We haven't asked specific people yet to come and volunteer, only because we don't want to get people's interest up and then say, well, it's only going to be a couple of years before anything happens. But just talking generally, we've both talked a lot to a lot of people about it, and a lot of people are very keen. And we do have people coming to our meetings now. A gentleman came last time, I hadn't seen him before. We have meetings about every 6 weeks. And I said, I haven't seen you here before. And he said, no, I've got 50 acres just out of town. I'm just keen to do this. So he'd heard from other people. We've been on the radio and talked about it, and people have come to us and said that they are interested. If that's an indication, then I would say that there is enough interest. See, if we were looking at 80 people a night homeless, if we aim for half of that number in tiny homes, it's not a lot of homes, and it's not a lot of people that we'd need to have. And I think out of a population of about 50,000, I think we could probably find them.
80.
Yeah.
Or
Or
40 for 2 on the property. And Mr. Riley, just lastly, you mentioned in terms of the current classification, in terms of Section 77, that largely it's there as a prohibition for Airbnb type accommodation, which is prolific in the Southern Highlands as well. Would you think that overturning the operation of Section 77 would be warranted, or do you think that there should be some exemptions to that?
Exemptions.
Okay.
Yeah. Well, I'll let Raymond talk to that one, because Raymond's the one that put our submission together in this regard.
It wouldn't need much in order to alter Regulation 77, in a sense that where it excludes those escaping natural disaster, one could easily just include "and homelessness," and that would resolve it to a large extent. But the second factor is also zoning, because when we discuss with council, the first question they ask, what is the zoning? So they're not focusing on Regulation 77, they're aiming for zoning. So we need to address the zoning factor, and also the exemption within Regulation 77 as well. We hope that would be sufficient, but based on past experience, no doubt council will raise some other regulation or whatever. But if we can address zoning and Regulation 77, hopefully that will open the doorway for us.
Thank you. So I guess the model instrument that the chair has exhibited takes care of the zoning question from your perspective. Is that correct?
I'm not familiar
okay.
with what's been proposed so
Okay.
far.
No worries. Thank you.
Ms. Higginson, do you have questions?
Yeah, thank you. Thank you. I echo the comments and really appreciate the work that you're doing in amongst the community. In the region I come from, the Northern Rivers, we've seen, and I think it was some of that was featured on there was an Australian Story piece about, particularly in the wake of disaster, women with young children or women over the age of 50 being able to access for the first time in a long time some independence and freedom to exist in a place they can call home, and these homes were these tiny homes on rural land. Do you think that if we are to suggest and recommend going down this path, there are some requirements that we should be addressing upfront and early to make sure that and to assist you that there are planning precautions to make sure that wherever we're placing people, they are safe, they have the expectations and needs fulfilled for those homes to be safe and sustainable in terms of things like access and sewerage needs and safety from further disaster and those sort of needs? And if so, how do you think we are best to do that?
That is a good question, and it's one that we have thought a lot about. I think as far as regulation goes, you can regulate all you like, but you're never going to fix the entire problem. The fact that we've got lots of churches together on this, we're very excited by, because it was funny, the pastor of our church first asked the question, do you think other people would be interested in getting together and seeing what we could do? Because other people were doing quite a lot themselves, we thought, well, they might not be interested, but they all jumped at it because it was something that was going to be for the entire community. Which is, I say that to say that we're looking at it in terms of, as I said before, we want the right people who own the homes to put a tiny home on their property. So it's not somebody that's just going to leave this person alone and not look after them. Because if somebody's escaping domestic violence, they need to just have some checks on them. We want to have security cameras on all of the tiny homes just for the people that live in there. We want to have the people that live in the house just give some consideration to these people and not necessarily be their best friend, but at least be part of their life. We want the tiny home to be of good quality, so possibly with solar panels, almost self-sustaining. It'll be connected. It'll have to be connected to sewer because council have told us that that's the way that would go, and electricity and water, all of those things. But in terms of the entire package, we want people who are going to continue to support these people, and that's why we want to be with Argyle Housing, because they have their own process for selecting people and making sure that things are okay in terms of whether it's the right person for the property. We want to be part of that process, and we want to look after things like gas bottles. When the gas bottle gets low, that we'll have somebody that will go around and change that and just have a visit. Raymond works with one of the food agencies, and he said once we've got somebody in, we would have people delivering food for these people, so we wouldn't have a problem in that regard. We think it's a complete package and not just one that legislation fixes. Now, I don't know whether that answers your question thoroughly enough, but in terms of the size, it's manageable for us. If there were 40 of these tiny homes, it wouldn't be too much for all of the churches in the area to be looking after these people, considering them part of their own. And so that's what we're hoping for, not just putting a tiny home on and saying you're on your own.
Mm-hmm. And just in terms of the location, so clearly the social settings need to be appropriate. In terms of those physical, environmental, at the moment you're saying you look to council for that guidance, but you think council may need some extra tools and help to be able to help you. That's kind of where we are.
I'm a very simple person.
Planning law is not simple.
No, it is
Yeah.
not, I know. And
Yeah.
I've looked through it and all of the regulations that there are for people in council, and I understand why they have them, and because people just look to them to be the responsible person. So something goes wrong, they're going to go to council and say, well, this is your fault. And that's not the case. We want, I guess, when we made this submission, we were just asking for a little bit of consideration in terms of some aspects of this, like the clause 77, because it would mean that we would have far less work to do and far less time to do it to get somebody into a tiny home. And that's all we really want from council. We know that there are considerations can be given and leniency in, for want of a better word, can be used or given. And I guess that's what we're after. We're trying to come part way to them. We're not trying to do this to make any money. And we've got a constitution where Raymond was the one who said, we want a constitution that never allows anybody, any of us on the board, to make money out of this, because some charitable organisations can ultimately do that. So we've done that because we want it always to be a volunteer organisation, because we want all of the money to go to these people. None of us are making anything out of this, and we don't want to. And we're not trying to sound better because of this, but we're just trying to say we want the best for these people and want to do it as quickly as we can. That's all.
Thank you.
Thank you, Ms. Higginson. Ms. Savall, do you have some questions?
Yeah, just a couple. Thanks, Chair. Thank you to you both for appearing today and for travelling up to give your evidence. It may be a silly question, but Lydia's legacy. I've tried to find out why you're called Lydia's legacy, but if it's appropriate, could you share with us?
Certainly could. Yeah. And it's funny because it's a question that's been asked many times, and it allows us to explain what it is. Because it was predominantly church organisations, we're not just church organisations now. Lydia was mentioned in chapter 16 of the book of Acts, and she was a woman that was well-to-do. For a woman to be so highly regarded in the times that the Bible was written was quite outstanding. She had a couple of properties in a couple of towns, but she was a woman who dealt in purple garments, which indicates she was an upper echelon person, but she helped her fellow human beings. And we wanted to make it her legacy because she did so much for people who were on the down and out, and she was obviously a wealthy woman. So that's all of that to say that's where Lydia's legacy came from.
And obviously exposing that I'm not familiar with the book of Acts. So
that's okay.
Thank you for clarifying that for us. In terms of the organisations that you have represented, on Lydia's legacy. There are a number of them, and I think you've already mentioned that some of them are doing their own work within the space. Has there been any work done to identify perhaps any surplus land or otherwise that these organisations may have that could assist with what you're doing, your pursuits?
Funny you should say that. But yes, we are looking and hope to get churches to put their land, some of their land. For example, the Seventh-day Adventist Church in Bowral is in one of the streets that runs into the main street, and it's about 1.5 kilometres from the centre of town.
Right.
It's 2 acres, and they have a church and a childcare facility, or I think it might be a kindergarten on it. They are willing and keen to talk. They just haven't had the opportunity yet, but they're keen to talk about using that land for a tiny home. We are too. But again, we want to get all our ducks in a row before we can actually say to somebody, okay, are you willing to do this? But other churches, there's certainly plenty of room around a lot of the churches, and we'd love to be able to do that.
So whether it's worthwhile the committee looking at perhaps the possibility of, because obviously there are the current restrictions which you've mentioned around tiny homes and the inhabitants of them, but whether it's worthwhile looking at tiny homes that are located on certain properties to have perhaps some increased flexibility. I'm not sure.
That'd be good, but it would limit things because, for example, the Baptist church where I go is where this all started. And it started, funnily enough, the minister there is a part-time minister, and he likes to keep the door open because it's near the main street. People come in all the time, use the bathrooms just to sit down and chat and whatever. And it was a fellow who came in that was in need, that he thought, oh, where am I going to go for this guy? So he started ringing churches, and that's how he got the idea of, this church is doing this is doing this. We've now created a resource list that council have actually put on their website, and it's updated fairly often, and it shows what's available and where. The problem would be this particular church doesn't have any room because it's in the middle of town. It's a small block, relatively small block, and a few of them are, and in the middle of town that would probably not be suitable for the zoning that there already is. We've looked at R1 to R5, which are smaller blocks than what this committee is looking at. But certainly where churches could, in some of the outlying areas. And we do have people in the outlying areas too that are willing, that have got larger blocks that would like to do this. So they're just waiting for us to clear the way.
And a final question from me, just around some of those constraints with the tiny homes at the moment. And I think you might have mentioned earlier in your evidence about challenges with Airbnb properties. That's something we heard up in the Tweed, where we had a hearing up in the Northern Rivers about some of the challenges that's posing. Is it something that we should look at as a committee with regards to, as opposed to trying to clamp down on the regulation of existing or tiny homes, but looking at other opportunities to restrict or curtail Airbnbs and how that is enforced? I know that obviously Byron Bay Council's done some work in that space, but is there opportunity for us to do something more in there?
I'll let Raymond talk to this in a moment, but I think there is. I think that there is, without having more and more legislation, you could facilitate this without opening the door for Airbnbs. And I know people exploit things all the time. They'll see a loophole and they'll go for it. But that's why we're asking for this specifically. As Raymond said, you could add a piece that just said or homelessness. And somebody might want to cheat the system there too, but I think it would be less opportunity. But I don't know whether that helps, if that answers your question.
Yeah.
There shouldn't be any inhibition on the other types of accommodation. I don't see a clash between what they're doing and what we're proposing.
Thank you. Thanks, Chair.
Thank you, Mr. Val. Well, thank you very much. Thank you for what you're doing.
Yeah.
We're very grateful, and I don't think we've taken anything unnoticed, but stay tuned for our final report.
Terrific. Thank you very
Thank
much
you
for
very
the
much.
opportunity.
Thank you.
Thank you.
Now, we're going to pause now for morning tea, and we'll be back here at 11:15 in 15 minutes.
Thank you.
Okay, welcome back. Can we ask our next witness to come forward, please? Now, our next witness is Mr. Neil Mumi. I'm assuming I've pronounced that correctly. Could you give us the correct pronunciation of your name and your position title and swear either an oath or affirmation?
Okay. The correct pronunciation of my surname is Mummy, as it reads.
Okay, good.
I run a small DA consultancy business on the New South Wales South Coast that operates statewide. We've done work in approximately 40 LGAs over the last 5 years. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given shall be the truth, the whole truth, and nothing but the truth.
Thank you. And would you like to make an opening statement?
Oh no, firstly, thank you for the opportunity to come and present to this committee. I think perhaps I can offer some insight as to what goes on at the grassroots level.
Please do.
With planning and as far as the DA approval process. Our work involves everything from deck extensions for people through to large subdivisions. We've got a multiple, obviously different types of clients, mums and dads, big developers, and I guess that puts us at the coalface of planning throughout the state. We have our biggest client is a manufactured home company in Western Sydney who provides manufactured homes to the bottom end of the market. When I say the bottom end, I say that with respect. It's a cheaper alternative for housing. There's certain frustrations around manufactured dwellings that we've spent 3 years trying to highlight to government because of some inconsistencies in LEPs across the state. So I guess the information or the evidence I give you today is based around the grassroots issues around DA planning through councils.
Terrific. Now, could you, you've worked across, I think you've worked with about 40 local government areas.
Correct.
About the modular homes, etc. Can you give the inquiry some idea of your interaction with the councils when it comes to the development control plans?
Development control plans, I personally believe, are the biggest handbrake to development in the state. They're complex. They are the bottom planning scheme, as everybody knows. And they're basically a wish list of what councils want their local government areas to look like. They're onerous in many occasions, and I could give an example. For example, Blue Mountains City Council, their DCP is 902 pages.
Wow.
Shoalhaven is 64 chapters. And all those chapters, while some of them are specific to certain developments, they still have to be read in conjunction with one another. So it's quite a convoluted process, and DCPs is the area where councils push back all the time.
So why are the councils opposed to these modular homes?
I think I had a conversation with someone in the planning department about 18 months ago, and there was a notion that this particular officer said to me, and I can't recall his name, said to me, we don't want the state to look like, have developers to have caravan park dongers, so to speak, throughout the state, which is kind of a rhetorical statement because they've come a long way since then. We do some work for a company out of Victoria into New South Wales, and they've won Victorian awards with their designs and things like that. So manufactured homes have come a long way since the traditional caravan park dong you'd see 30 or 40 years ago. Once they're installed and established, it's fairly hard to tell them from a normal dwelling.
And how have you found the New South Wales planning portal? What's working and what's not working?
The planning portal, well, apart from the fact a lot of the times it's dysfunctional, it just won't work. You can sit there when the thing spins between screens and go and make a cup of coffee and come back and it might have loaded the next page. It doesn't interact well with each part of it, like the construction certificate part doesn't interact with the Section 68, doesn't interact with the DP. So you're constantly uploading different information and actually cheating the system to get it to accept it. The other thing that's become apparent in the last 6 months is, I'm not sure when it happened on specific dates, but the planning minister put a directive out to councils that they had to accept DAs within 7 days of lodgement, which there is logic in that, but at the same time it's forced councils to find a minor error and reject the DA
I see.
without even contacting. Like, I had one yesterday at Shoalhaven, and I've had this issue with them before where the owner's consent had, for example, J. Smith. Their rates notice has J. Smith on it, and they throw it out of the portal because it hasn't got the full names on it. And they also operate outside, some of the councils operate outside the requirements of the EPNA Act as far as lodgements, and they use that as an excuse at lodgement stage. That effectively slows the whole process down again. The other thing with the planning portal I think councils hide behind is once they accept an application, they can sit on for 3, 4, 5 months, and then they'll send what they call a request for further information, and they expect it to be answered within 7 days, or in some cases it has to go back to a consultant. So, and it's just impractical to make that happen. So the portal's good and bad. I can understand why the government uses it, but at the same time it has got its drawbacks.
And am I correct in thinking, I read in your submission that New South Wales is the least friendly out of the 6 Australian states towards these manufactured homes?
100%. They're go-ahead full on in Queensland, Victoria, Western Australia, South Australia, everywhere. But the problem with New South Wales is an anomaly in the LEP that drills down to definitions. There's half a dozen, an increasing number of councils that are using that as a reason to push back against manufactured homes.
So is this in the other states, you mentioned Queensland, is this like a growing industry, or is it something that's just a niche industry, or is it something that's, and are there what are the negative consequences that we've seen from the other states?
I couldn't talk for the other states, but certainly in New South Wales there's a lot of room for growth. For example, the company I work for in Western Sydney, they would turn away 4 or 5 a week because we know the councils won't allow those types of applications. And particularly as one big southwestern Sydney council who even refuses to take secondary dwellings, which by law they're supposed to, but they just refuse to take it.
So we just heard some advocates in favour of tiny homes. Just so we can get our head around what these modular homes look like, what would be the typical cost for a standard modular home? Not the land, but in terms of just the construction costs.
A 3-bedroom, 1 bathroom, which is a standard type of home, between $250,000 and $300,000 installed.
What challenges to development have you experienced from biodiversity conservation strategies and bushfire conditions in proposed development zones?
Bushfire and biodiversity are conflicting interests at either end of the scale, as you would understand. But I think we've got a situation where on some residential blocks that have been established for many years, when in certain local government areas, if someone needs to take a tree down to install a home or build a home, even the traditional build, councils are asking for arborist reports and all those, imposting all these extra costs or tests of significance that I think is grossly unfair when that land's been zoned for residential. And we're talking 500-600 square metre blocks this happens, which have been in residential areas forever and a day. So there is total conflict between biodiversity and bushfire. I understand the need for both. Bushfire is probably something that councils do have to hang their hat on more than biodiversity, or then again it depends what local government area you're in. For example, Blue Mountains, you cannot lodge a DA without an arborist report. Doesn't matter what's on the block, even if it's a small bush, and a landscaping plan, which adds about between $8,000 and $10,000 to the cost of an application for the owner.
A lot of money. Well, thank you. Do we have a question from Ms. Saval?
Yeah, thanks, Chair. Thank you, Mr. Mummy, for appearing today and for your submission that you've provided. You mentioned in your opening statement some of the challenges facing getting modular housing or manufactured homes permitted. I just wondered if you could expand on that, if you have any suggestions for the committee to make.
Okay, I think the biggest issue, the building commissioner the original building commissioner made a statement about 2 years ago that he doesn't like manufactured homes. Now that could be for a personal reason, I don't know. Certainly manufactured homes are not controlled as much as a regular build by a builder on a site. But the main issue that exists in this state at the moment is the LEP, which every council has an LEP that sits above, which is a mandated state document. There's an anomaly in that LEP under definitions, where it drills down through what's a permissible use in a zone, then it goes down, it'll say dwelling house, you go to the dictionary, the definitions, and it'll say dwelling house, everything except a manufactured home. Now the way I've suggested this to the planning department and various ministers. Obviously, I haven't had a response, but I understand that.
We can suggest it to us.
Yeah, so it's the simple way or the easiest way to deal with manufactured homes is treat them like any other home, as in mandate critical stage inspections in the factory that are normally done on site, make them subject to homeowners warranty, take them out of consumer law, make them subject to homeowners warranty, and make them comply with BASICs. That instantly levels up the playing field and eliminates all those grey areas about critical stage inspections and how they're handled. That would be a simple way I know it's not as simple as just writing that and doing that, but that's the basis of how to bring it up to make them accepted in every
And
council
would
area.
there be any other, because obviously the state government through our own Homes New South Wales has looked at and is building modular homes as a way of addressing some of the issues with the homelessness and housing crisis. Would there be any other opportunities or avenues that you could see in terms of what's contained within the LEPs or
I was encouraged to see the planning circular that came out recently that effectively has removed manufactured homes, I think, from the building reforms. So they I'm assuming they're going to be handled different. They could be done under a SEP. The other issue they have is they're subject to the Local Government Act, which instantly creates confusion between the Local Government Act and the EP&A Act. So to simplify it and take it, but they're installed by way of Section 68 under the Local Government Act, which is tied up to the manufactured homes and caravan parks, which is in itself confusing. Has got a different set of rules to a council LEP. Now at the moment I've got a certifier in Shoalhaven who wants to apply that act, and that the planner wants to apply the DCP. So there's total confusion within that building as to how to handle the application. But yeah, it could be simplified. It's easy because I sit on the outside. I don't understand the complexities of legislation, but what I see is there is a simple fix: is mandate critical stage inspections, like if you have a house built on the site, make them comply with BASICs, make them pay homeowners warranty, level playing field, all bets are off. But it will take a change to every LEP to remove that anomaly.
You also mentioned, I think in your earlier remarks, a South Western Sydney Council not permitting secondary dwellings. Why would that be the case, that they're not permitting?
They're hanging their hat on that LEP anomaly. So even though a dwelling house is a separate definition to a secondary dwelling, and a secondary dwelling doesn't prohibit manufactured homes, but this council has just had a no attitude forever.
Is it
And
just
just a clarification on that, is that just with respect to a manufactured
Correct.
secondary dwelling? So,
Correct.
but they are
Correct.
permitting, okay.
other secondary? Okay, so that's a very important clarification. Thank you. Thank you
Yep.
for that. Yeah.
Yeah, the manufactured
council?
home for secondary dwellings is a great solution.
Yeah. Which
It's fine.
council is this?
Am I allowed to say it?
Yeah.
Yes.
Campbelltown.
Thank you.
You've also got Windsor Carriby, my own council, Urabadella.
Yep.
There's a couple of others, I can't remember them, but it's an increasing number.
Okay, so it's not an isolated thing. So potentially something the committee should look at, whether or not, if it's, perhaps a widespread issue across a number of councils where they're just having a blanket.
It's a growing number.
Yeah. Okay.
And all I can assume is that when council planners go to their annual conferences, they all talk about it because they seem to be lining up and falling over.
Okay. Interesting.
Which is a concern because, as far as secondary dwellings are concerned, they're a great solution to a quick fix to housing.
How good as a
and some
primary
manufactured-
dwelling.
Excuse me, some manufactured dwellings because they're fast.
Yeah. Yep.
But
Yep.
it's ever since I was the mayor at Urabadella for 5 years. Sorry, from 2005 to 2008, I took an active interest in planning because that was when the then minister Frank Sartor brought out the LEP template, and I've seen that now across every council watered down. So maybe that needs to be looked at again. The LEP standard template, but it also would be great if we could have standard DCP conditions within reason. I understand each local government area's got its own issues, but
Yeah.
setbacks, heights, and things like that could all be standardised.
Thank you. Thanks, Chair.
Thank you. Miss Higginson, do you have some questions?
Yeah, thank you. Thank you very much. I remember the old introduction of the standard instrument very well. I saw that. But yeah, my understanding, and I think we heard evidence earlier about how and I'm asking you this question, you do see, though, that some localisation of those standard instruments can drive good localised planning outcomes?
For sure.
Yeah, thank you.
For sure, 100%.
Yeah. One of the things I just wanted to clear up, and I've seen this where, council will write to proponents and say, these are the things you've got to address, you've got 7 days. With that, it is your understanding that you have 7 days, but if you don't provide in 7 days, it's all okay, but the clock stops and then you have further time to provide that material. Is that the case?
We've got situations where they've asked for extra information and given 14 days, and we've written back to the council, so we cannot physically supply that because the engineer is away on holidays, and their answer is if we don't get it within 14 days, we'll refuse the DA. Or they'll continue the assessment with the information they had, which will end up in refusal.
Right.
So, and what's really frustrating about that is you have a planner who's doing a DA.
Yes.
They'll just up and go on holidays for a month and nothing happens, nothing to see here. But they send us an RFI and give us this time frame. So there's inconsistency, and it's not equitable in that respect. But I think it goes back to DCPs and a lot of the issues too. Like, for example, Upper Lachlan is in the process now of revising their DCP. Now that's a council that will probably get 40 DAs a year. Their draft DCP is 200 pages. So every DA needs to go through it. And you just get to the point where you go, this doesn't work with that, doesn't work with that, sorry, we can't do it.
Yeah, we made, I think that goes back to those Sartor days when there was that provision that a council may only have one DCP. So, and I think the intention was to streamline them, but instead all the councils just put all their DCPs into one giant document. So, and yeah.
Like I said, Blue Mountains is 902 pages.
Yeah.
Shoalhaven's 67 chapters, and that's just, and they're ones we work in quite regularly with manufactured homes, and it just gets to the point where you say, and it's so blinkered, the approach, it even gets down to where a letterbox has got to go. If they'll come back and say with an RFI, that letterbox is not right, that garbage storage area, and you think, who is going to go and check this after the house is built? Same with landscape plants. They mandate all this stuff. The house gets built, people plant the plants, they don't water them. Who goes and checks it?
And can I ask just 2 quick things? With your evidence where you said, which I've never understood either, the Local Government Act and the Planning Act in terms of manufactured dwellings and caravan parks and so forth.
Yep.
Is it from your expertise, is it your preference to see it all up into the Environmental Planning and Assessment Act now?
Oh, look, if they could roll the manufactured home situation into a SEP,
right,
that instantly overrides an LEP. That solves the problem with permissibility.
I see.
Because a SEP sits above it. So,
yes.
And I think a SEP would have the opportunity to set out the guidelines.
Yep.
Where it's all set out really clearly. If you meet that, you're fine, because you can't. It's impossible to alter a SEP. You have to stick by the guidelines of the SEP. So if the SEP sets out the guidelines and they're fair and reasonable, that is the solution. And add to that mandate the critical stage inspections, homeowners warranty and the BASIC's compliance.
Yes.
Problem solved.
Thank you. And just finally, I know you gave evidence about the single tree. Would you also appreciate the fact that from time to time, if there is a proposal to remove a single tree in a particular neighbourhood, that could have some quite significant impacts in terms of amenity, habitat values, and neighbouring neighbour desires as well?
Don't get me wrong, I've got great respect for biodiversity.
I hear that.
I think there's been some really poor examples of people that have cleared stuff that is reprehensible behaviour, but I think we've got, when you have situations, particularly in the regions where you've got, say for example, 2,000 square metre blocks or 5 hectare blocks, and there's no biodiversity mapping on it, and effectively you can, and it's bushfire prone, so you add that thing to it, and you have to put an on-site management system in for wastewater, like a traditional septic for wastewater management. You effectively need about 5,000, an asset protection zone of about 5,000 square metres. Now, some councils, even with a recent subdivision, which this should have been addressed at subdivision, but it wasn't, with proper building envelopes. So the owner of that property, unbeknownst to them, because they're not advised properly by conveyancers at time of purchase, they have to go and get a test of significance, in some stages a biodiversity report, in some instances they have to pay offsets, and all of a sudden these people, they see a cost of going, they buy their dream block of land and they haven't done the true due diligence, or their conveyancer hasn't, but they're up for tens of thousands of dollars just to get the site ready for a house. And I think it's an error of conveyancers, but it's also an error of councils and planning issues, because these things should be addressed at subdivision. They should be in perpetuity, and they're not. They're revisited by councils quite often, which I think is kind of grossly unfair to the landowner. But I take your point about significant trees and things like that, and totally respect that. But very rarely they don't turn up on residential blocks.
Yeah.
You know, they might be in a nature strip or something like that. But you know,
Thank you.
Yeah.
Yeah, thank you. Thank you, Chair.
Thank you. Mr Deputy Chair.
Thank you very much, Mr Mummy, for your submission, for your being here today and for your lived experience with the system and being able to help us navigate it. Just interested, you are going through the litany of challenges that people are facing in the system, and you were outlining to the Chair that the typical cost of a manufactured home, $250 to $300 for a 3-bedroom, 1-bathroom.
Yep.
From your experience, what are you paying in consultancy reports and the like to be able to actually get it approved and get it on a block?
If you keep in mind, GST is a separate issue
Yep.
on everything, but that's a given cost. We tell, if it's a straightforward, clear block with no issues, it's about between, well, the council fees vary from council to council. If they've got to put a septic system in, for example, there's one council charges $4,000 to put a septic in. All the others are between $500 and $1,000. There's so much inconsistency across every LGO with costings. But to get back to your question, we would say allow between $12,000 and $15,000 to get to an approval.
Okay. Now, with respect to the manufactured home, and I take your point of what the Building Commissioner might have said a few years ago. I know, as a former Building Commissioner, he came before one of our inquiries, and he made the point with manufactured homes that he didn't want to see two classes effectively in terms of building regulations. I think what you're proposing addresses that issue in being able to have those checks at similar points and being able to ensure standards.
Can I just interrupt there? The Building Commissioner said 2 standards of homes. Manufactured homes are built to comply with the BCA. So the BCA is the overriding document that dictates how they're built. So I don't know how we got to get to that. Probably, I would say he's done that because of the inspection regime, where in factories they're signed off by engineers. An engineer technically can't do a critical stage inspection. It's got to be a certifier. So I'd say that's where he's got the 2 classes of buildings, but they are built to comply with the BCA.
Yeah. Just going back to your point, though, in terms of that regime that you would put in place, would you see that being run by the Building Commissioner in terms of those inspections and the like, or?
Oh, I think if you were to, if let's say, for example, in the ideal world, a SEP was created for manufactured homes, and it had to comply with all the BCA issues, which they do, is it really becomes a private certifier issue, because they would be retained by the manufactured home company to go and undertake the critical stage inspections in the same way that a builder does in a traditional build.
Okay.
So they'd have to pay a certifier to do that.
And with respect to the demand that exists at the moment for secondary dwellings, and of course we're looking at secondary dwellings on rural properties largely, are you seeing that most are looking at going the way of manufactured homes on their sites, or a preference for that vehicle rather than going for a traditional bricks and mortar property?
I couldn't comment for bricks and mortar, but I'd say most secondary dwellings are limited in size under an LEP restriction to 60 square metres. That's the kind of benchmark, which is a quite, 2-bedroom, 1-bathroom, 1 lounge room kind of thing. 60 square metres is not a big dwelling. I guess it's your traditional granny flat size.
Yeah.
So the company I work for, it would be 60% of the work would be secondary dwellings.
Okay.
So, but in regional areas, there's also, this is where the LEP's broken down across the template, is some zonings don't allow it in some of the regional areas, which is, I'm just dumbfounded at why they're not, and we try and relies on the housing set to do that.
Yeah.
But councils won't accept that in a lot of cases. So, for example, in C4 in some local government areas, that zoning and environmental zoning, they won't allow a secondary dwelling. But if you look at some of the permitted uses, it doesn't make sense why they don't allow that. So that's another problem, is that the permissibility under the zonings is not consistent.
And look, I think we've heard consistently, and I'll declare a conflict here, I live in C4 myself, but I think we've heard quite a bit of commentary from people coming before this inquiry cautioning us in terms of any application on C3 or C4 zoned land. I'm just interested in your perspective. You obviously have a different view in that regard and think that it could be a permissible use?
I think if you've got C3 and C4 land that are dwellings permitted on, or a dual occupancy is committed on, there's no logic or there's no merit in the argument to say you can't have a secondary dwelling. Because by their very nature, a secondary dwelling is a small footprint. It's not a big building.
And would you constrain that to a property of a certain size, or?
You could, but most C3 and C4 land is 1,000 square metres plus. They're big blocks by and large. Because the smaller blocks are all R2 and R3, which is your medium to high density. Your R2, your low density zones, where you might have a 550 square metre block that permits a secondary dwelling. You might have a C4 block that's 5,000 square metres that doesn't, but it will permit a dual occupancy. So there's inconsistencies there too. I mean, I know you can't have one size fits all, but I think the LEPs themselves need to be looked at and trying to be standardised a bit more than what they are, because what works for this LGA doesn't work for that. And it's particularly rampant in regional New South Wales, where they're all different. And it's just becomes challenging, and I don't think it's conducive to sensible development where, for example, a secondary dwelling can be placed close to a primary dwelling and provide elderly parents somewhere to live to keep them out of care as long as you can. There's a bunch of positives of why secondary dwellings should be permitted almost anywhere, but there's certain places they can't, which is obvious. But I think there needs to be a more pragmatic look at how and where they're accepted. Basically because of their size, they're not big. They're not a big footprint.
Thank you, Mr. Mumley.
Welcome.
Well, just before we wrap up, Mr. Mumley, I'd like to just read out your conclusion in your submission. Modular housing provides a vital and immediate opportunity to address the housing crisis, particularly in regional New South Wales. However, without urgent legislative clarification and consistency across LEPs, this sector faces extinction in New South Wales. So if we do nothing, at what point would your industry be facing extinction?
My fear is the way that the councils are slowly but surely calling up this anomaly in the LEP, it'll have a snowball effect. As more and more will jump on board. For example, Eurobodalla came on board only this year because there was an issue, someone objected to one, and they had a high-level planner write the objection, which deliberately went to that thing in the LEP. Some councils overlook it. They just say, we're not concerned about that because we're concerned about our ratepayers and our residents. We want to look after them. But when they become a problem, councils just fall over and say, no more. So that concerns me.
Okay, well, look, thank you for your valuable contribution. Our time has come to end.
Thank you.
Thank you.
Thank you.
Well, we welcome our final witness for the day. And could you please state your name and position title and swear either an oath or an affirmation?
Andrew Edward Kearns. I'm the Manager of Strategic Planning at Hawkesbury City Council. I solemnly, sincerely and truly declare and affirm that the evidence now and about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And would you like to start by making an opening statement?
Yes, thank you. So I'm addressing the Select Committee today as a representative of Hawkesbury City Council and would like to thank the Committee on Rural Housing and Secondary Dwellings Reform for this opportunity. As detailed in our submission, Hawkesbury City Council welcomes the inquiry, supporting efforts to improve housing options in rural and peri-urban areas. whilst also recognising the importance of maintaining productivity, amenity and character of rural areas. Hawkesbury City Council supports the introduction of detached dual occupancies and secondary dwellings in rural zones, and that's evidenced through Council resolving recently to prepare a planning proposal for detached dual occupancy development in certain rural and environmental zones, and that's actually very recently received a gateway determination from the Department of Planning to proceed, subject to conditions. Council is also seeking the introduction of the Standard Instrument Clause 5.5 in relation to secondary dwellings in rural zones as well. And in actual fact, whilst being sought through this current planning proposal, Council has been seeking to permit detached dual occupancies and secondary dwellings in rural and environmental zones since our efforts in 2015 and 2016, both of which did not proceed past the gateway determination stage. Council recognises the numerous benefits of permitting dual occupancies and secondary dwellings in rural areas, which will assist with housing affordability, housing diversity and options, supports multi-generational living and potentially strengthens the rural economy, provides cost-effective housing solutions without the need for subdivision and associated infrastructure. Through Council's research in preparing our current planning proposal to permit detached dual occupancies, this has identified there are a number of Sydney Metropolitan Councils and other councils in New South Wales that do currently permit detached dual occupancies in rural zones, and as such, the permissibility of such uses is not uncommon and can be managed through specific development controls, including DCP provisions, that particularly avoid fragmentation of land and avoid land use conflicts. I guess recognising that the primary use of that rural land is primarily, in most cases, primarily agricultural. In terms of potential impact on population, we don't really see a difference between attached and detached dual occupancies. Detached can provide additional housing and maintains a lower density appearance, can preserve rural character and minimises environmental impacts. And as mentioned earlier, potential negative impacts can be mitigated through DCP controls or provisions. So those controls could relate to siding, size, distance between dwellings, driveways and access, and in terms of environmental hazards, ensure controls in relation to flooding and bushfire management. And in closing, it's also worth noting that last week the New South Wales Government released the draft Sydney Plan and discussion paper, a new approach to strategic planning. That exhibition runs until the end of February next year, and depending on the timing of the findings and recommendations of this inquiry, there may be an opportunity to input into the draft plan and future state land use plan. In so doing, ensures a clear and consistent line of sight between strategic and statutory planning in New South Wales. Thank you.
Well, thank you. So it is possible now in the Hawkesbury to build a second dwelling, but as long as it is attached to the existing home. Is that correct?
Dual occupancy, yes, and I guess the distinction is dual occupancy and secondary dwellings. They're different land use definitions in the LEP. Yep. So dual occupancies are permitted if they are attached. Yes. And
so it's possible, but then how popular has it been? I mean, people don't want to live sort of right next door to another family. So has it been taken up?
Don't have high numbers in terms of applications in rural areas for those uses as yet, and that was in our planning proposal that we submitted to the Department of Planning. We sort of provided the numbers of going back to 10, 12 years in terms of numbers that we provided. Yeah, relatively low numbers that in terms of that. Yeah.
Now, about 10 years ago, the council did write to the planning department and did request that you would be permitted to build a second dwelling that was not attached. Was that request made to change your LEP, or was it the SEP?
So in 2015 and 2016, council applied for planning proposals for detached dual occupancies and secondary dwellings in all rural and certain environmental zones.
Yeah.
So it's through a council-led planning proposal. Yeah.
And why did the department refuse that request?
So both requests were didn't proceed past gateway stage of that because of concerns about regional flood evacuation issues. and potential increases in population and impacts to evacuation in the Hawkesbury and Nepean Valley.
Well, we know that the Nepean, Hawkesbury has flooded for hundreds of years from time to time, but I mean, it's quite a big council and some of it's a long way away from the river and elevated. So what did you think of that decision by the planning department? Do you think that was too arbitrary to make that apply to the entire council area?
You're right, there's I guess a significant portion of the local government in the area that is not directly flood affected. Obviously there's some areas that, whilst they're not directly flood affected, they do have secondary impacts from flooding in terms of isolation, cutting off of services and so forth. So, but I guess, dealing with the matter on such a broad scale, I guess we did find problematic, yeah.
And how do you feel about if these reforms do come in and people were in your area allowed to build a detached home, how does the council feel about the situation of raising rates? Would you ideally like to see an increase in rates if there was two homes on the one property?
Look, I'm not an expert in terms of rates, so my expertise is in terms of strategic planning and policy and strategy. So rates I won't comment on. Yeah.
I understand. Mr. Deputy Chair, do you have some questions?
Thank you very much, Mr. Kearns, for your attendance here today. I'm just interested in terms of the decision you made with respect to C3 and C4 as well for the policy to apply to those lands. Can you just walk us through what sort of considerations the council made in making that determination?
Yeah, so that's a consistent approach that we had in our 2015 and 2016 planning proposals, include the rural zones and both of those environmental zones. Essentially the uses that are permitted in those zones includes dwellings and dual occupancies, so we thought there was merit in proceeding on that basis.
So dual occupancies are already permitted?
If they're attached, yes.
Okay.
Yeah.
Oh, the attached dual occupancies at present?
Yeah.
Okay. And with respect to the appetite that there exists in the community, how many, now that you're looking at changing the policy and gone through the gateway determination to have detached secondary dwellings, do you think there's a lot more interest in landholders proceeding to have a secondary dwelling on their property in a detached setting?
Yes, definitely. So obviously since the council resolution to proceed with that planning proposal, there's been an increase in the number of inquiries about when people can potentially make an application for those uses. Obviously it's still a process to go through with the LEP amendment, and but yeah, there has been a marked increase in inquiries in that respect. Yeah.
And so when do you expect this to now be in place following your gateway determination?
So we have, as I say, very recently received the gateway determination. That includes a number of requirements to update the planning proposal and supporting documentation, also referral with a number of public agencies as part of that process, and then public exhibition. Council's been provided until August next year to finalise that LEP amendment, but it's obviously in our interest that we proceed through that process as quickly as we can. Yeah.
Thank you. And now, while it will be permissible in those zones, applicants will still have to go through the development application process, will they? Or?
Yes, so this is basically to make those detached dual occupancies and secondary dwellings in the rural and environmental nominated environmental zones permissible, so we'll go through a development application process.
And you heard the evidence before of Mr Mummy with respect to modern methods of construction or manufactured homes. What's the approach of Hawkesbury Council when it comes to such dwellings?
I guess there's the similar challenges. Obviously, we're dealing with the same state legislation in terms of the manufactured homes being under separate legislation. Obviously, previous witness sort of talked about the challenges as an applicant, but it's also challenges as a regulatory authority as well with dealing with different legislation and different requirements for land use and for the buildings through the manufactured homes. So I think there is the opportunity to potentially look at some sort of legislative reform in regard to how manufactured homes are dealt with. Yeah.
And does Hawkesbury Council take the approach or the view at the moment that they are permissible in terms of manufactured homes?
So for manufactured homes, we have a local approvals policy responding to the Local Government Act. So the particular challenge for us is where there is interest in manufactured homes. They've primarily been on the floodplain, and particularly as part of caravan parks. So they're obviously heavily flood affected, and our local approvals policy has a number of criteria that needs to be considered and responded to by any applicants under that. Yeah.
Thank you, Mr. Kearns.
Ms Higginson, do you have some questions?
Thank you. Mr. Kearns, I just wanted to raise about the concerns that the department put to you in relation to the planning proposal. The evacuation capacity of certain parts of the Hawkesbury LGA is very real, isn't it?
Most definitely, yeah.
Yeah, I know that I had the benefit of being on a previous inquiry a couple of years ago that was after some of the flooding, and was taken to a number of locations, and it was quite... I'm from Lismore, so I know a lot about flooding, but it was... I couldn't believe some of those areas and what the matters that you as a council had to grapple with in terms of proposed increases of population in certain areas. Was there ever any initiative on part of council to go back to with an altered planning proposal about limiting perhaps some of the areas where the secondary dwelling could apply in the LGA, or was it just kind of shelved for now?
Yeah, so the 2015 and 2016 planning proposals were across the whole LGA, and they were the ones that the department didn't allow past the gateway determination. As part of our LEP review planning proposal that we looked at that on the basis of applying those provisions above the flood planning level, so above the 1 in 100. And I guess for context, for Hawkesbury, particularly in around Richmond and Windsor, our 1 in 100 flood level is in the order of 17.3 metres, and our probable maximum flood is now over 30 metres. So we're talking about some very significant depths of floodwaters that we're talking about. And the state government, the Resilient Valley, Resilient Communities strategy for the Hawkesbury and the Nepean Valley actually describes our valley as probably the highest risk, flood risk in New South Wales, if not Australia.
Yeah, thank you. And your submission makes it very clear that where you are proposing that potentially second dwellings would be applicable in particular zones, you say, however, development consent is something that should be in the mix with this because of all of these variations and factors.
Yeah, certainly for, there's I guess a number of environmental hazards, particularly flooding for us, but obviously bushfire hazard that I think are critical. But I think for local government areas, there's enough distinction between the rural areas of different local government areas to warrant having nuanced controls for each local government area. That would obviously be through development control plan provisions, and that then allow assessment of applications under that particular development control plan. Yeah.
Thank you. And we've heard, maybe the chair put this to you, but do you think that there is any role potentially for a state environmental planning policy or do you think it's best done with the LEPs and the DCPs?
I think through the LEPs, but I mean there is obviously the opportunity for an overriding step that amends all LEPs rather than each council having to go through an LEP process. So that if there were I guess findings from the inquiry that made recommendations in terms of certain provisions, they could essentially be applied through an amending step that amended all LEPs rather than each council having to go through a process to do that.
I see, so like an enabling step to then operationalise.
That's right.
Fantastic,
yes.
thank you.
Yep.
That's really all I had, thank you, Chair.
Thank you.
Sorry, one final thing.
Please.
Just in terms of Hawkesbury, how do you have biodiversity mapping overlays?
Yes.
And in your biodiversity mapping overlays, do you consider them up to date, fit for purpose, and proving to be well informing overlays?
Yes, so we've had some very recent mapping and work that's been undertaken in the last 12-18 months that is very up to date and is very fine-grained, detailed in terms of that. Yeah.
And sorry, just one other final thing. I think you are the area that is first cab off the rank in terms of the Reconstruction Authority's adaptation.
Disaster adaptation plan.
That's right.
Yes.
Is that, how are you going with that? Where are you up to?
Well, obviously, the Reconstruction Authority is preparing the disaster adaptation plans. I think it's been delayed somewhat, so we're quite keen to see where that lands, and also understand that they have taken out the land use planning controls from that process and undertaking that as part of a separate process. So there'll be an adaptation plan, but the land use planning will be dealt with separately. Yeah.
Annie, do you have, is there anything information you've been provided about the rationale for separating those two tranches of work?
Look, it's probably just the complexities and challenges that do exist. I mean, Hawkesbury and Nepean Valley, it is quite a different valley in terms of the impacts of flooding within the valley. Penrith, for example, a lot of the flood is contained within the banks of the river. It's only sort of higher events that it spills out over the banks, whereas when you come to the Hawkesbury, it basically you end up with the bathtub effect, where the floodwaters just spread out so far.
We just need some plugs, don't we?
Well, yeah, that's yes.
Yeah. Okay. Thank you, Mr. Cairns.
Thank you. Mr. Vaz, you have
Thanks,
some
Chair.
questions.
Thank you, Mr. Kearns, for appearing today and for your evidence so far. I wanted to ask you about the introduction of the new planning proposal with regards to detached dual occupancies. I think you're aware the committee's undertaking some site visits this afternoon out in the Hawkesbury. In terms of areas where they have on-site effluent management, so septic systems, has there been consideration for how that will interact with the new planning proposal with relation to dual occupancies?
Yeah, so the gateway determination that we've received from the Department of Planning has required us to prepare a draft development control plan chapter, and that will be one of the considerations as part of that. There's a whole raft of other considerations as part of that chapter, but obviously servicing both in terms of sewer and water treatment on site, whether it's obviously preferences for on-site treatment as opposed to pump-out type systems. Yeah.
In terms of the secondary dwellings, I noticed your submission also suggested clear differentiation between the two, that's on page 3 of your submission towards the bottom, in terms of the term second dwellings, which conflate dual occupancies and secondary dwellings. Is there any suggestions that you have for the committee in terms of better trying to differentiate between the two? Because it seems to be consistently coming up with the evidence we receive from councils, whereby secondary dwellings have to be, or in many cases, need to be at that subordinate size, as you've referenced in your submission, but dual occupancies seem to have more flexibility, opportunity perhaps. So it's interesting as to why more people aren't using that as an avenue to get their sort of development or secondary, additional property on their house.
Yeah, so obviously these particular terms are standard instrument definitions, so every council has to apply those definitions. So each council doesn't have definitions for each of those uses. So I guess for the committee to understand that there are distinct differences between those defined uses, the secondary dwelling versus the dual occupancy. As you say, the secondary dwelling is more of that subordinate nature, whereas there's a bit more flexibility with the dual occupancies. Yeah.
And so with Hawkesbury Council, what is currently permitted in terms of secondary dwellings?
Secondary dwellings is primarily made permissible through the housing SEP, so in terms of, and that's primarily limited to more urban areas rather than rural areas. Yeah.
I noticed you've also provided us with a helpful table describing some of the councils that currently have the detached dual occupancy permissibility in rural and environmental zones. There seems to be many differences, and it's interesting to see it's quite a diverse range of councils. Have you any suggestions? So the state government obviously could look to perhaps play a role in facilitating that or making that easier for local councils, but there clearly still needs to be that localised decision making. So are there ways that the committee could look at suggesting, for example, a mechanism to encourage more councils to take up that opportunity?
Yeah, so I think there is opportunity for model development control plan type provisions relating to these types of uses that could be applied by councils, and if there was a decision by the state to include all of these, uses as permitted uses through an overriding SAP, then obviously that model code would assist councils in responding to that.
And in your submission, you also seek some clarification around the scope of this inquiry, particularly regarding the inclusion of outer metropolitan local government areas. That's something that was highlighted, I think, also in the submission from the New South Wales government. Do you think that we need to take a somewhat different approach when looking at the outer metropolitan versus some of those more rural councils, or should it be just something that we open up to all?
I think it's just in terms of clarity, in terms of what specific local government areas these findings or recommendations would relate to. Yeah.
Okay.
So that there's no ambiguity in terms of that. Yeah.
Yeah. Thank you. Thanks, Chair.
Thank you. Well, I've just got one last question. That is, across New South Wales, there are reports that there's a lot of unauthorised second dwellings in existence already. Is that much of an issue in the Hawkesbury area?
Potentially, I don't have any figures around that, and it's not something that we, in an active sense, pursue on a compliance regime. Yeah.
Well, that's good to hear. You're not actively persecuting them. But if the proposed change to the SEP make the current unauthorised dwellings legal, for lack of a better word, would your council grant amnesty to these dwellings?
I think council would certainly consider that. I don't know what the outcome would be, but there'd certainly be an appetite for consideration of that. Yeah.
I'm pleased to hear that. What would be the mechanism for that? Would that be like a resolution of the council, or how would we go about giving these people certainty about what the physical reality is?
I think, for us, it would be a resolution of council. Yeah.
Right.
Yeah.
Okay, Mr. Kearns, well, look, thank you very much for coming along. We enjoyed your submission, and we will be visiting your wonderful local council area later this afternoon.
Very good. Thank you.
Thank you.